believe it or not, coming from a black American, I actually think it's going to be a fair trial. I don't think the racial tension is going to affect the case. I believe in the judge. I also believe in the prosecutor, and I heard that Mike Howard, the attorney for the defense side, is actually good.
Those are comments outside of the courthouse where we are in Texas this hour for day one of the Karmelo Anthony trial. He's a defendant charged with first-degree murder for the fatal stabbing of 17-year-old Austin Metcalf at a high school track meet. Key pieces of evidence in this trial are going to be the surveillance footage from the stadium and witness statements. That surveillance video has already come out inside of the courtroom, but we're taking a look at what those statements were in the police report from the people who witnessed the incident. So a school resource officer was taking down these statements in the police report. Let's take a look at witness statement number 1. And this is a minor, a witness that was sitting under the Memorial High pop-up tent with his team near the victim, Austin Metcalf. The suspect, Karmelo Anthony, was from Centennial High and was sitting under the Memorial High tent. Austin told Karmelo that he needed to move out from under their team's tent. Karmelo grabbed his bag, opened it, reached inside, and proceeded to tell Austin, quote, "Touch me and see what happens." No one really thought Karmelo really had any weapons in his bag, and Austin proceeded to touch Karmelo. Then Karmelo told Austin to punch him and see what happens. A short time later, Austin grabbed Karmelo to tell him to move, and Karmelo pulled out what this witness recalled as a black knife and stabbed Austin once in the chest and then ran away. Let's talk about what that statement means for this case. Joining us to discuss, we have trial attorney Mark O'Mara still with us and former prosecutor Nicole DeBoard with us. Thanks so much for being with us and breaking down this case for our viewers. Nicole, I want to start with you. With that witness statement, if you're just focusing on that, if that was the only witness to take the stand in front of this jury, do you think that this sounds like murder or self-defense?
I gotta say, this is gonna be a tall mountain to climb for the defense. It sounds very much like murder. There's a couple of things that really create an issue here because under Texas law, you cannot bring a weapon to a confrontation. And based on that statement alone, essentially what we're hearing is that the person who was provoking the encounter, because he's saying, touch me and see what happens, is actually the person who has appeared at the encounter with a weapon. Certainly that's not going to be what the defense has to say about it, but I will say this does sound like a tall hill to climb in terms of self-defense.
Yeah, the defense did try to clean that up in their opening statements with whether he said, touch me and see what happens, or touch me and don't touch me and we'll be cool. Mark, I want to show you witness statement number 2 in this police report. This witness stated to police that they were all sitting on the bleachers under a Memorial High tent when another male he did not know walked over and sat under the tent. That would be Karmelo Anthony. Austin told this male that since he didn't go to Memorial, he had to leave the tent. Austin and the male went back and forth. Then Austin stood up and pushed the male to get him out of the tent. During the time of the arguing, the male was reaching around in the bag that he had. It was at this time that the male took out the knife and stabbed Austin and then left the scene. They're substantially the same, Mark, in terms of what they are saying. There are a few differences, but what's your take on whether or not from those witness statements at the time that this happened, where do you think the jury would land on a case like this?
You know, it's fun. It's going to be a tough call. And I know that's an easy thing to say. You can't lose if you say you're in the middle. It's going to be a tough call for these reasons. When you actually do an analysis of self-defense, there are different components. You know, the argument that Karmelo Anthony was there and he shouldn't have been there. Well, that's okay, but it's not your bleachers. You don't get to throw people out because of a tent. That's an argument that you're going to see the defense make. Why did the eventual victim in this case decide that it was his role to kick him out? And then there's a tussling back and forth. And then, unfortunately, Mr. Metcalf did seemingly start the fight, so to speak, right? He was what we might call the aggressor and pushing him out or grabbing him and touching him. So under Florida law and also Texas law, and when you're the aggressor, when you first start the fight, so to speak, you may lose the protection. If it was Karmelo who started, Karmelo Anthony. Now we get to say shifted because if Metcalf was the one who started the fight, now can Anthony respond to defend himself? We know he can. And then as was mentioned a moment ago, are you supposed to bring a knife to a fist fight? No. You're supposed to bring a gun to a fist fight? Absolutely not. But if you're there and starting to get attacked, which is what the defense is going to say, can you defend yourself? And what they're going to say is, Anthony doesn't need to wait until the first nasty strike, the first injury. He can presuppose what might happen, and he's allowed to defend himself. But again, a tough case, because it really is in the middle, and we're talking about two 17-year-olds and not making fun of it, but neither of which were acting with real good reason. We joke and say that a male brain isn't fully developed until 25, and unfortunately the tragedy happened probably because of a mix of testosterone and immaturity that brought these two boys together.
Yeah, Nicole, we talk a lot about whether race has a factor here, but I think age has a really big factor here. And not only the age of the defendant, the age of the stabbing victim, but also the ages of these witnesses who are going to be having to take the stand. This has been a traumatic experience for them, seeing their friend stabbed in front of them. Do you anticipate that they'll be able to shed more light on what happened, or even if at the height of this, they'll be able to say whether there was this initial aggression that Mark is talking about? But at what level would it actually be warranted for self-defense, do you think? I mean, there's this push in the police report, there's the shoving, there's the grabbing. I saw that word in the police report as well. What would it have to be in order, in your mind, to be self-defense?
In order for this to be self-defense, the law says that the person using this deadly force has to believe that that deadly force is immediately necessary to prevent serious bodily injury or death. So this is self-defense. You cannot pull out a gun or a knife, a weapon which can be used as a deadly weapon, say, in response to a minor assault. That's unfortunately not what the law allows. If you think that you are at risk of being seriously harmed, it is a different calculus. So that is what the defense is going to have to demonstrate. And really, the Texas law on the defense's side, one thing that might potentially make this a little bit easier for them is once they have made a claim that Karmelo actually believed that he was in imminent danger of serious bodily injury or death. There's evidence of that in front of the jury. Once that happens, essentially what has to happen is that the prosecution has to disprove that. So these witnesses that we're going to hear from, which are just these young kids who are essentially, going to a high school track meet, have to be able to get up on the stand and really explain what was going on. And, on the prosecution side, I think these are going to be really compelling witnesses because of their youth on the one hand. On the other hand, they're going to have to endure adult cross-examination.
Oh, yeah. And speaking of cross-examination and people being on the stand, Mark O'Mara, I know we have to go to break soon, but I want to get your final thoughts. The defendant taking the stand, do you think it's a good idea? Do you think it is necessary here? Will we see that happen?
We always know that our own client is always our worst witness and his own worst enemy. And that's the problem. However, in a self-defense case, you almost have to take the stand to say, here's why I did what I did. Don't forget, self-defense is an affirmative act. I did it, and I intended to do it, and here's why. So you have to say the why. The other problem that the Anthony team is going to have to overcome that's relevant under Texas law and Florida law is if you're doing an event that you perceive to be self-defense, then once the threat is gone, you have an affirmative action to fix things a little bit. Flight away from the scene actually hurts the defense because once you've stabbed, once you've done what you had to do because of your self-defense right, okay, threat is gone, help, render aid, call the cops, stick around to give your opinion of self-defense. And I know we're talking about 17-year-olds, but anyone who leaves the scene and then argues self-defense is sort of inconsistent with their behavior.
Oh, yeah. We're going to talk a lot more about that and exactly what police say he did after he fled. Mark O'Mara, thank you so much for lending us your time and spending time helping us analyze this case. Nicole, you're going to stick around. We have a lot more ahead. We're going to take a closer look at what was said during those opening statements. Camera's not inside of the courtroom, but we have the notes, and we're going to break down what was said by the prosecution and the defense as day one of this case out in Collin County, Texas begins.